XRP and Ripple fans, good morning. Article in the Bitcoinist today says that Ripple say that the SEC summary judgment motion is unlikely to be granted, says their lawyer. Our favourite fan lawyer, Jeremy Hogan, has once again commented via Twitter that the current state of the court case between Ripple Labs and the SEC. Hogan cited attorney John Deaton, who represents over 75,000 XRP investors in the litigation. After Judge Torres denied Deaton's motion to intervene, she allowed the filing of the amicus briefs. Now, as a result of this, Deaton filed his amicus briefs for all XRP investors last week. Of Deaton's group, more than 3,000 took the opportunity to file an affidavit. Now, according to Hogan, the SEC will not be able to meet its burden of proof on at least one element of the Howey test. This is where Deaton and the XRP investors who made their voices heard could play a crucial role. As Hogan went on to discuss, the SEC must do two things in order for summary judgment motion to succeed. First, it must prove every element by greater weight of the evidence and prove that there is no genuine dispute of a material fact. However, this factual argument is built on very shaky ground. Specifically, the argument that is that XRP investors bought into the token based upon Ripple's promise of a higher price. To that end, the SEC is solely relying on a few statements from a tech company and a handful of buyers. Its own expert on the subject has left the SEC. This extract says the SEC offers no evidence related to knowledge or conduct attributable to Amici or any XRP holders. SEC expert admitted that he might have to come to a different conclusion upon learning that XRP holders acquired XRP for non-investment purposes. Now, Ripple has also countered the SEC with its own expert witness correlating XRP price trends with market forces, especially since 2018, and in addition, the company now has 3,000 affidavits from Deaton and XRP holders who did not buy XRP because of Ripple. Hogan therefore concludes that the SEC has failed to meet its burden of proof over the past 2 years. A handful of statements over 8 years versus an expert opinion and 3,000 affidavits. But even putting that aside, is there genuine issue of material fact here? Ripple has submitted direct, hard evidence that a reasonable XRP purchaser was not relying on Ripple to increase its price. We don't see how the judge ignores that evidence and grants summary judgment on this prong of the test. Not saying the SEC can't win, but it can't win here. What do you think? Drop us a comment, let me know what you think, like, follow, and get on that comment.